the criminal procedure of South Africa. In Kenya, we have section 163, 75. In Malawi, there is the section 133 of the Criminal Procedure and Evidence Act, 36 of 1967. Can I repeat the section? Yes. Section 160 of the Criminal Procedure Act of Zambia. Section 77 of the Criminal Procedure Act of South Africa. Section 133 of Criminal Procedure and Evidence Act, number 36 of 1967 of Malawi. And lastly, section 163 of the Criminal Procedure Code, chapter 75 of Kenya. If you look at this section, they are almost similar. Say, where it appears to the court. For example, the court, and it can be either from the observation of the court, or maybe the prosecution applying to say, for assessment, this person is incapable of understanding what is happening here. And sometimes even defense counsel, because most of these cases, criminal cases, they are legal counsel to get instructions from this client. So when the question arises, the court is required to inquire, investigate whether that person can stand trial or can give a defense. From my experience, notwithstanding that the CRPD, because these sections, none of them the court calling for a medical expert. But the practice that, notwithstanding the CRPD, courts have not yet moved away from the medical child model to the human rights model. That's my observation. Question, when it arises, the court requires into the allegation. Then the proceedings, which means the criminal is in charge for murder, for assault, the proceedings will be postponed. Usually the practice won't change up now. Is the court asks a medical certificate or a testimony. The medical doctor comes to court to say something. And then the court will make a decision to say this person is fit to stand trial or is unfit to stand trial. From my understanding, I noticed that this provision, it offends, it does not respect a person's human rights. The procedure itself, it offends human rights, including autonomy, liberty, choice, and consent. They are not involved in the process. So there is the right to equal recognition. Because when the court finds that you are unfit to stand trial, in almost all these provisions in common law countries, the court simply enters a plea of not guilty and will proceed to hear the case, whether the court is participating or not. End of hearing the case from the prosecution from the state, the court will make a ruling whether the evidence that has been presented warrants him to be convicted or to be acquitted. That's where the problem is. So you are not participating. So there is lack of access to justice there. And when you are found guilty, the court will make a special finding. The accused person will be detained in the presence of pleasure. And where you are guilty, The very fact that the medical opinion says this person is a they'll still be detained in a psychiatric hospital. So it offends the right to equal recognition, right to travel, because you are just an observer. You are not even participating. Then personal liberty, you can change. Others, the right to security, dignity, and autonomy, including the right to free and informed consent. Because if we go into the CRPT, Article 12, it expresses the right to autonomy, will, and preferences, including those with disabilities. Maybe due to lack of communication, you are unable to participate. It says mental capacity can vary according to circumstances. Sometimes maybe it's just fear of being caught. According to circumstances or environment, that has nothing to do with the person's disability. Then Article 13 clarifies the right of access to justice by stating that everyone, including the defendant, the accused, witnesses, victims, or state, there are no qualifications or rules for one to before a judge, and the right to interpret person's feelings, wills, and preferences, and give effect to them. One example, the matter of I think I ended.
Thank you. So let's get back to the case. And I think listening to you, a lot of us are thinking, so what is the alternative? How do we move away from, the current way we fitness central, what does the alternative look like? Perhaps that's something you could reflect on a little bit later. So I'll go back to Shepard and pose the question, how can the different stakeholders collaborate in order to ensure access to justice for persons with disabilities? What does that look like? What the different do?
Thank you very much. My proposal would be that the various sectors be conscientized, and this conscientization should even start by the overhauling of the various curricula for legal practitioners, for the police, and other health personnel that deal with persons with disability that end up in court. Remember, we are not just the police, the lawyers, the magistrates. We are also looking to probation officers, who are social workers. We are also looking into medical do those examinations. So there should be interactions between these stakeholders. From my jurisdiction that is Zimbabwe, we used to have meetings that would meet monthly. The prosecutors, the magistrates, the police, the social workers, and they will discuss on ways to improve the handling of matters for attend vulnerable witnesses. from the loose definition of what vulnerable witnesses are, with disabilities fit into this particular scenario. So if there could be collaborations, constant interactions and exchange of supported by appropriate legislation, I think that would help to improve the proper dispensation of justice with regards to persons with disabilities. Thank you.
Thank you for that. And over to your experience both in Kenya and your work in the region and abroad. What are some of the best practices or good practices that we can learn, we can adopt, like in terms of the work of intermediaries?
That's a good question. I am part of the International Intermediary Forum. It's an international forum for intermediaries worldwide, and we do a lot of learning within that forum. I think what I love about what's happening in different countries, and especially of course the West, is that there's a lot of systems for intermediaries. So the law intermediaries. Intermediaries are called in immediately that something happens. They are trained and accredited and are paid for their role. They have, backing from government to do that. No one can actually tell an intermediary to leave court. It has never happened to me. So I think what we need to do is first of all, I think dissect what our laws say, because that's where most of the issues come. But the people who are doing well in this world have clear legislation on intermediaries, they have clear rules for intermediaries, they have bounds for intermediaries. So for example, a communication assistant or facilitator in the UK is different from something called friends of person. I think Dan, you remember that name. There's this different person who gives support in court. So what I think I like is that there's just clear defined bounds of this. There's one who comes to assist with the person's emotional needs, and then there's the intermediary assisting with communication needs and very formal needs in the system. So yeah, I think the best thing is having these systems very much researched in the different ways that it can work. For example, difficult or with people with very high support needs, people who cannot stay put in one spot. There's a lot of different accommodations, a lot of innovation the world over, and I think that's what I the best time.
And tell you to share a story you wanted to share, but also reflect on what alternative.
I think the alternative in the area of fitness to stand Trump, okay, the difference is that in almost all the countries now we have constitutional provisions. Our rights are enshrined for the right to a fair trial. I think it should be progressively interpreted to mean it includes disabilities, and that courts should measure whatever procedure is adopted, whether it's calling of a medical expert, it should not be of the justice. It should be interpreted in line with our fundamentals in the right to a fair trial, whereby the court should be encouraged to move towards measures, accommodations, flexibility. The people of Essence Joshua, it's on go. It happened in Cape. This person was charged for murder by the facts were that a person got offered, who was his cousin, went to school with a school plastic bag belonging to the accused without their permission. So it was very defendant was very upset, said I will with him. Then he came to acoustics, he wanted to come and hit this mobile in Oxford. But the deceased, the victim, prevented and threw them away. Then Kapai is dumb and deaf. So Kapai he could express ways to say, I'll deal with him when he knocks on. So he entered the house. He went to pick up a school shirt belonging to the same mobile so that he could tear it. Then the deceased followed him inside the house, trying to grab the shirt away. And the next thing was shout to say, he has stabbed me. He walked with abdomen. Then the knife was found in the house. But when the police officer went on the scene, the police officer decided in court to say, none of the witnesses told me that there was such an argument and that the incident happened in the house. I was only given a knife stained in blood. So this person, and he said he interviewed the accused with the help of family members in unconventional sign language. He didn't have formal training on sign language, the accused. So when he appeared in court, the court looked for a sign language interpreter, but the accused couldn't understand the form of sign language was used. So the court proceeded by quoting section 160 to say, because it's death, we shall proceed plea of not guilty by reason of disability and proceed to trial. Now, the miscarriage of justice was that the man's system for investigation into that disability. So for me, that inquiry should be developed in such a way that it leads to a supportive decision making so that they participate as opposed to substitute. Because the finding, the special finding was based on disability down death. And the person was found guilty. And yet the judge relied on testimony from the arresting officer, relied on relatives to interpret. Yet the judge said, I will not allow any relative to come in court and interpret, give a biased interpretation. So for me, one of the best practices is that these provisions should be interpreted in such a way that they lead to access to justice by provision of supportive measures, any form of support measures, because these people, we all come from communities, and there are several ways in which we communicate. If the court can reflect to now to adopt any mode of communication and interpretation, so that everyone participates, that will be so progressive.
Thanks, example. And so this brings us to the end of our session. You can see the relief on your faces. Yeah, this brings us to the end of our session. I wanted to thank the panelists for sharing experience and your expertise. I wouldn't say this conversation is parked. And hopefully we can really continue and engage more tomorrow. In autumn, race. I think there's a lot to discuss. So, is the justice sector, dispensing on duties. But we'll pack that for this afternoon. Please get behind a round of applause for. And then even bigger round of applause for yourselves. Thank you. You've been a captive audience. You've really engaging, and it really just takes